Welcome to the new edition of Unprecedented, only on Legal AF, the YouTube channel. We have Dina Sayegh-Dahl and Michael Popok here. We look at all things United States Supreme Court from a 360-degree angle, both what happens inside the court, outside the court, and things that involve or have some sort of connectivity or connective tissue to the justices or the United States Supreme Court. And we've got a lot to talk about as we're about less than halfway through the first term. Got some breaking news that will actually connect back to the United States Supreme Court, because that's the way these things work. We're gonna of course talk about the fact that Judge Merchan in New York has just ruled at the state level that the criminal convictions of Donald Trump are going to stay, the 34 count felony convictions. He's not going to throw away and throw out the jury verdict, but he has some thoughts about how to sentence Donald Trump, and he's picked a date, and it's before the inauguration, January the 10th. But it's complicated. We're going to dive into it about what the judge has indicated to both sides and what I like to refer to as a tentative ruling, that where he's leaning, where his head is at, about what type of sentence he would impose on Donald Trump. You'll be on the edge of your seat. I certainly was in getting through the 18 pages of it, and we'll talk about it here. And within that order of the judge, which on its surface was denying yet another motion to dismiss by Donald Trump, under a unique set of a unique law in New York, we call a Clayton motion, where you're arguing that it was manifestly unjust for him to be convicted. The judge has rejected that and then turned it to sentencing. But Judge Merchan also mentioned the annual report by Chief Justice Roberts, issued each year about kind of the state of the judiciary and the state of the Supreme Court. We got our hands on that as well, and Dina and I will give you what that looks like and what looks like is keeping Justice Roberts up at night. And I'm not sure he's going to get any sleep anytime soon with Donald Trump coming into office in less than 20 days. Then we've got some new reporting about Clarence Thomas in the news again, about ethics issues and about whether there'll be a referral to the Department of Justice about his ethics issues to determine whether there was a crime or anything else. I know there should be a referral, but we'll give you the straight scoop about whether there will be one. And then there's the Biden administration is still in operation, still open for business. Joe Biden just today broke the tie and decided not to allow U.S. steel to be sold to Nippon Steel, a Japanese competitor. His Justice Department is still investigating and prosecuting, like in New Orleans and in Las Vegas, with the attacks there. And he's taking positions, including in court, about anti-money laundering statutes that may have implications about the incoming Trump administration. We'll break it all down right here on Legal AF and on Unprecedented. Dina, back from holidays, looking great. How are you?
I'm tired. It was fantastic, but lots of different family time. And so, yeah, I'm so glad to be breaking this down. There was a lot that actually did happen. And so, yeah, let's get into it.
So let me, if you don't mind, I'll take the lead on the Merchan ruling about the Trump and the sentencing, and then you can take it from what the United States Supreme Court could do now that the state courts are ruling about sentencing and appeals, when they get involved, if they get involved, and where do you think they end up on the area of sentencing a person who will be 10 days away from being president and likely, in his term during the appellate process. So we've been waiting, weeks now for Justice Merchan, who's a justice of the state Supreme Court, which is, just to be confusing, is what New York refers to its trial level court as, on the state side of this equation. I said in a hot take the other day, or during the midweek edition of Legal AF, that it's coming any moment. I'm like, it's going to come. I thought it was going to come before Christmas. And then I thought maybe before New Year's, and I just missed it by a few days, that he was going to try to, clear out all of these issues so they weren't hanging over Donald Trump and the American people. And if Donald Trump has appeals that he wants to take, he's got time to do those things. So we were waiting on the judge to rule on whether he was going to grant what's called a Clayton motion, named after a case, a 10-factor motion that the judge is asked to weigh about whether it would be manifestly unjust to have the conviction stand, or whether there were facts and factors that would allow him to just throw away the jury's hard work to find Donald Trump convicted 34 times. we thought that after that, there would be a subsequent order related to sentencing. I think Karen Freeman Ignifilo and I on Wednesday, I predicted that he would sentence before the 20th. She didn't think so, but definitely we both agreed that he wasn't going to be going to jail anytime soon, certainly not before he took office. And that's where we left it at that moment. Now we've got the judge's decision all wrapped up in his order. What he's done is he's chastised Donald Trump's lawyers for crossing the line a number of times in their rhetoric, accusing the court and prosecutors of criminal activity effectively. And he's rapped them on the knuckles for that. It's interesting because two of the lawyers that represent Donald Trump are going to be two of the top officials in the Department of Justice, starting in about 10 days, well, after they get confirmed. So that was interesting. And then I went to the back of the 18-page order about what the judge was going to rule after he got through it all. And then in conclusion, we got, all right, he's going to be sentencing him on he found no immunity. He found no presidential immunity, presidential-elect immunity, separation of powers issues, supremacy clause immunity, nothing that would stop him from actually sentencing or throwing away the conviction. He set a date. I'm like, okay, you got me now. January 10th, that's great. But when you read earlier, he tips his hand and he goes through in the sentencing section, which is on page 17. He rejects a number of the proposals by the people of the state of New York, represented by the Manhattan DA, about, well, why don't you just keep the conviction on the books, but why don't we temporarily abate the proceeding and we pick up with sentencing in 4 years? Judges, I don't like that, because I don't like that, because if he's got appellate rights, then he needs to be able to take his appeal now. And I don't like sentencing him now and holding the sentence in abeyance until he's done being the president. I don't like that either. And he said, I'm inclined, subject to further briefing, to do what's called an unconditional discharge, which in New York means what it sounds like. There's no conditions. He doesn't have to do a darn thing. The conviction stays on the books, but forever. He's forever a felon, but there's no sentence. There's no imposition of a punitive sentence, not even community service, let alone jail time. I asked for 1.5 years. I thought that was an appropriate balance given the other cases around this area. And then he made a reference to Chief Justice Roberts in our next segment. But why don't you pick up with what do you think Trump's next step is, Manhattan DA's next step is, and how does this come back to the United States Supreme Court?
And for the sentencing hearing, I think it'll be interesting to see. Typically in a sentencing hearing, both sides will have witnesses. The prosecutor will put up witnesses showing the harm that was caused by the defendant and why this sentence should be more severe. Here, I imagine they should even talk about the fact that he never accepted responsibility, no remorse. Those are typical things that we would hear. On the defense side, you would hear why why you shouldn't be sentenced that much, right? What a good standing citizen you've been, and you've never been convicted before. It'll be interesting to see if the Trump puts forward anything like that. I hope that the DA treats this like a typical sentencing hearing and puts forward, witnesses and shows why Trump should get more than an unconditional discharge, because frankly, that's their job. They brought this thinking this was a serious crime. You can't stop now after you've asked a jury to convict him. I think you should continue with forcefully defending the reason why you thought it was so serious to bring with. But how the Supreme Court gets involved. So he gets sentenced, as you say, it's final. Then he starts the appeal. The only time the Supreme Court comes involved is if there's something that's unconstitutional in the conviction. And so here, there could be many things, right? I mean, criminal defendants argue all the time certain things in their trial are unconstitutional. The Supreme Court typically is very unfriendly to criminal defendants. Not even just the Supreme Court. The Supreme Court legacy is not usually very friendly, and which is why, by the way, it was such a plus that Justice Ketanji Brown Jackson was a former public defender, because people who advocate for criminal defense rights really believe we need more public defenders as judges. But that's an aside. So he could, come up with some argument that we haven't even thought of. But the argument we think he's going to bring to the Supreme Court is this related to the immunity decision, specifically, as we've talked about on this channel many times, whether or not the Hope Hicks testimony or anything any evidence related to while he was in office, does that come under the broad umbrella that the Supreme Court decision had, which was essentially if evidence, was related to his official conduct, that can't be introduced, even if the crime had to do with private conduct. But I think it was absolutely, but those kinds of evidence decisions, let's say, whether or not evidence is introduced at trial, is always kind of litigated, let's say, post-conviction typically. I mean, we're going to see as part of that appeal whether or not Stormy Daniels' testimony went too much detailed into her sexual act. That could theoretically go up to the Supreme Court too, but probably doesn't implicate constitutional issues. It's just a matter of, was it prejudicial versus relevant? But the constitutional issue that we would expect to go up to the Supreme Court would be, how does that new immunity ruling apply? And to be honest, like, we shouldn't be afraid of the Supreme Court taking that, because their opinion was so vague. They're going to need to explain it at some point, whether or not it's with Trump or some down the line. Their decision was so vague, they're going to end up clarifying it and narrowing it in a way. And whether or not this is the case they do it in, we don't know. And but we will talk about it if it comes up there. But that's the preview to how the Supreme Court's going to get involved if it does.
Yeah, I agree with you. He's going to. He doesn't like the ruling by Merchan about because he already went through this immunity decision already, so it's ripe for appeal as soon as the rest of this is done, which is that it was harmless error, that the few things that were allowed in, several of them were waived by the defense for failure to object. He basically said the Cohen testimony was effectively waived because it wasn't objected to, that the Madeline Westerhout testimony was waived because it wasn't objected to. The only thing was like one small part of Michael Cohen, and then Hope Hicks. And the judge said there's an overwhelming mountain of evidence that the jury would have relied on, naturally would have relied on, including witness testimony, that makes those few stray strands of evidence, even though they may have technically violated the immunity decision, and even there he didn't think that was true, it's not enough to overturn or find reversible, or define that it was dispositive for the jury, and therefore he denied it. That issue will go up to the United States Supreme Court on immunity because, it's a guy who argues he was present for one aspect of the trial, testimony, and they're going to have to take it up or not. I mean, the first stop on the train, if it's going to be an emergency appeal, is going to be Sonia Sotomayor, who is the Associate Justice in charge of New York. And if she can go, no, or she can refer to the full panel, full body of 9 justices and let them decide. She'll probably refer it in, and they'll decide whether they want to bail Donald Trump out on that issue. If they find, that's not really that exciting, there's a couple of stray pieces of testimony, we're not revisiting our immunity decision again so soon, could happen. They've sat on their hands for other immunity-related issues related to Donald Trump. E. Jean Carroll, when he lost the Second Circuit about the immunity decision, the immunity doctrine, absolving him of any liability and defamation against E. Jean Carroll for the sexual assault that he was adjudged to be. They've still not taken it up. They're not interested. So, but just because immunity is the I word is there, doesn't mean that it's automatic trigger for the Supreme Court to get involved. But the way you mapped it out is exactly the way I believe it's going to happen. Let's turn to the comment that I'll read out loud the comment from Justice Merchan, New York State Supreme Court. And then you can start talking about the Roberts Annual Report, which is the end of the year survey. I joked with our friends at Court Accountability Action that if that was an annual report for a corporation, it would be the subject of a securities fraud suit, right?
Right.
There would be lawsuits flying out of it because it was so dishonest with the review of what just happened at the United States Supreme Court. And I think it's actionable, but not when Justice Roberts does it. But here's what's on Justice Merchan's mind. Second footnote of the decision about the sentencing that we just talked about for Donald Trump. It says, this court recognizes that the lawyering by both prosecution and the defense has been exceptional and spirited throughout the entirety of the case. It is clear that the people have prosecuted this matter to the best of their abilities, and the defense has represented their clients zealously. There have, however, been instances when, in written submission, counsel. Now, at first I thought both, but when you read it, he's talking to Trump's lawyers only. Because if he talks about the other side, he says the people.
Hmm.
So counsel has come dangerously close to crossing the line of zealous representation and the professional advocacy one would expect from members of the bar and officers of the court. And this court has at times made counsel aware of its observations and concerns. Now, however, counsel has resorted to language, indeed rhetoric, that have no place in legal proceedings. For example, countless times in their motion to dismiss, counsel accuses the prosecution and the court of engaging in unlawful and unconstitutional conduct. These terms are also peppered throughout defendant's reply. Those words, by definition, mean criminally punishable. In other words, you're calling a judge a criminal. You're
Yeah.
calling the prosecution a criminal without
Yeah.
more, without
Yeah.
any evidence.
Yeah.
And that's a big no-no in
Yeah.
court. He then goes on to say, this has the potential to create a chilling effect on the third branch of government. Indeed, Chief Justice Roberts, in his 2024 year-end report, we're going to talk about it now, just came out on the 1st of January, on the federal judiciary, felt compelled to address 4 areas of illegitimate activity that, in my view, do threaten the independence of judges on which the rule of law depends. 1, violence; 2, intimidation; 3, disinformation; and 4, threats to defy lawfully entered judgments. JG. So it's on their minds.
Yeah.
I think it was in a different context as Roberts brought it up, but certainly it's something now. You see how quickly in our world things end up being published and announced and decrees made, and they end up right in the water supply and end up in other cases and cited by other judges. So why don't you take the lead now on for our audience about what Justice Roberts' 18 pages of blather was all about, and what did you make out of it? What do you think's keeping John Roberts up at night? And what were these veiled criticisms of who, of what, and the like? And tell me if you thought, I'll leave you a one posit. Tell me if you thought there was a sort of a tip of the hand for Roberts about how he may rule in the TikTok case about foreign influence and disinformation. Turn it over to you. Turn it over to you.
Yeah, I thought of that too, actually. So, and just because I know we get a lot of comments about this, just to put it out there, like people will say, like, why doesn't Justice Merchan like sue for defamation, let's say, right? Or Alvin Bragg sue for defamation when they say that kind of stuff. You know, we have something called litigation privilege, which allows the parties a lot of latitude in what they say. And you can't be sued for defamation for the most part, because the idea is to allow everybody to like fully flesh out their case in court. But the problem in this day and age is when you see, when Trump says that in his thing, people, his followers, whatever, will say, oh, see, they're unconstitutional. He said it's unconstitutional. But anyway, just for everybody out there, maybe you sometimes have to kind of read all litigation documents with a little bit of grain of salt, because they don't have to adhere to that really strict, let's say, truth that other things do. I mean, they do, in that if they're lying, the other side can quickly point it out and they kind of lose credibility. But okay, so that's an aside. Back to Chief Justice Roberts. Chief Justice Roberts, the state of the nation in terms of the judiciary, he seems scared. Shocker. We've talked about this over and over. They're losing trust in the public. And some of the things specifically that, standing out is him talking about the threats to the judiciary, how some judges now have to wear bulletproof vests in public. And, we've talked about this, how much Trump, all of his threats against Justice Merchan, and how so many of his supporters, the angry, texts and emails and threats. Judge Chutkan too got a lot of those threats. So, I'm in agreement with Chief Justice Roberts that this is out of hand, because Trump is able to just pull his MAGA supporters and, go after any judges that he doesn't like, which, is wrong. We don't want judges to have to be like physically, threatened and worried about their safety. It's one thing to criticize and not, but, this is, yeah, like we can talk about it all day at Legal AF, and that's not going to change if Trump and MAGA aren't willing to change. And then and then he talks the interesting thing, and really him speaking to Trump. I know you talked about this, Popok, already, is him saying his fear that public officials won't follow the opinions. And it is true that the Supreme Court can have an opinion, or frankly, you can enforce some of opinions, lower opinions, with injunctions and that kind of stuff. But for the most part, especially a Supreme Court opinion, if somebody's saying this is unconstitutional, they can't do it, they don't have a mechanism really to enforce people to follow it. And so if you have Trump, who wants to be, as he says, a dictator on day one, or just flouts the law, or President Musk, right, let's say, goes on his X and says, let's not follow that law, there's nothing really forcing somebody to follow that law. And so Chief Justice Roberts is previewing that. He knows, he sees, we all see the desire to really disparage our institutions and not respect our institutions. And what does happen with the courts, with the Supreme Court, who does not have a mechanism to enforce it? So strangely, I'm also in agreement with there too, but you've kind of created a monster in Trump with the immunity decision by giving him so much executive power. One way of checking to make sure somebody doesn't act above the law would have been to allow him to be criminally prosecuted for his actions while he was in government. And they took away that mechanism. So he did create it. But the part about the TikTok, his other thing that he's concerned about is, he said, social media. He's concerned about social media. And what he says is disinformation about the judiciary in particular. He says, I don't mind criticisms, but disinformation about the judiciary in particular, he's worried about. And I thought, maybe he's been watching our show, Popok, because we're criticizing them all the time. I frankly don't see a lot of disinformation criticisms about the judiciary on social media. I don't know if you have ever seen anything, Popok, but for the most part, the judiciary isn't really talked about a whole lot on social media. I think it's a little bit of a like an intellectual discussion that a lot of people, frankly, aren't that involved in. So I thought that was kind of an interesting take. And I did think that he was showing his hand about TikTok, because his worry that social media is hurting his court may make him more likely to want to ban TikTok. So I thought that was interesting, but I don't know if I've seen actually any evidence of what he's talking about.
No, I thought it was a very bizarre, diversionary report in a year where he could have talked about the impact of the immunity decision on people's belief in the credibility of the court, or their decision on the 14th Amendment under Anderson, or in Justice Alito flying upside down flags of insurrection, or the millions of dollars of ethical violations by Clarence Thomas. He chooses to defend his turf and then signal out the American people, who he says much of the criticism comes from people who don't know what they're talking about. It's like, oh, so I've lost my First Amendment right to criticize, legitimately criticize. And then everybody that he's describing appears to be Donald Trump. I can't think other than the attacks on the judiciary in the form of public officials, i.e. Democrats, who have tried to hold the Supreme Court accountable in their, like the Senate Judiciary Committee, with calling Roberts on the carpet to talk about the ethical violations. When are you going to pass the ethics code? Then he passed the ethics code. It has no teeth in it. Then he rejects the calls to come talk to Congress, claiming it's a violation of separation of powers. You can't get me because you're a different branch, and so he seems to be chafing at that and the attempts to rein in the Supreme Court. And then everything he talks about, I was thinking, this is Donald Trump. There's only one person out there who's consistently attacking the judiciary and members and their family and judges and jurors, and trying to destabilize it. And that person has a name, and his name is Donald Trump. It's not Joe Biden. It's not Hunter Biden. It's not Bob Menendez. It's not any other Democrat who's in the crosshairs of an investigation or a special counsel. It's Donald Trump. And that's why, and Rashawn saw it. Rashawn's like, Rashawn could have said, he could have gone one line further, but then he would have been accused of being partisan. He could have said it's an obvious reference to Donald Trump in these lines, and I agree with it. But it is an obvious reference to Donald Trump.
Mhm.
So that was weird.
Mhm.
You created the monster, and then you stand back and you point at it and go, the monster. Yeah, well, you created the
Yeah.
monster.
Yeah.
The way you destroyed the co-equal branches of government and the counterbalance and the checks and balances that we don't have any longer because of the Roberts Court.
Mhm.
And so for him to say, well, oh, I'm aghast, there's gambling going on here, it's just totally not disingenuous and dishonest, intellectually
Mhm.
dishonest.
Mhm.
On the TikTok thing, I thought it was really weird. Nothing's done by accident. So he
Yeah.
knew he was going to publish this before January 10. And
Mhm.
he knew that people were going to speculate that when he said one of the threats is foreign interference in our marketplace of ideas, in trolls, in disinformation campaigns, that's at the heart of the TikTok case. The Biden administration and the Congress has acted. This is a law on the books already, that TikTok is an instrument of the Communist Party in China and is being used to destabilize our national security. We're not just watching it and making videos, they're watching us and getting information from us in a huge, giant database. And peering into our souls through TikTok, through the Trojan horse of TikTok. And that's why the federal government and Congress has acted. The question is whether that's constitutional or not. And now you
Mhm.
got if I'm the TikTok lawyers and I read that, they better be ready for their oral argument on how to address Roberts' issues about platforms and disinformation by foreign actors, because
Mhm.
they're not. I mean, if he's smart, somebody's going to actually ask. Hopefully, it's in the record. Is ByteDance, which owns TikTok, owned and controlled by the Communist Party of China?
Mhm.
Yes or no? So
Mhm.
I'm sure it's in the record. Somebody's going to have to answer that question. And if
Mhm.
it is, we know that China would never let the U.S. have a social media platform that was spying on its people.
Right.
You know,
Yeah, but they also don't believe they don't have a First Amendment right, constitutional right. I mean, that is actually the argument that I know we're going to talk about TikTok later, but that's the
Mm.
argument that's put forward in the amicus briefs defending the reversal of this ban is like we are acting like those repressive governments like China that doesn't allow in Facebook when we don't allow in a foreign social media. Like we've been screaming from the rooftops how awful China is that didn't let in Facebook, and all of a sudden we don't want to let in TikTok. So
Well, yeah, that was good. Let's debate. Let's go. Let's debate
yeah,
that. So
let's
you've
do it.
got So you've got the ACLU, who I love, who
Yeah.
often takes unpopular positions, and has argued successfully for the rights of Nazis and American Nazis to march down the streets of Holocaust survivors in Skokie, Illinois, and the KKK to march and protest, and Proud Boys and Oath Keepers and all that, as long as it doesn't turn violent. And they've taken the position that whether you take it from the 140 million Americans that are on the platform or you take who have First Amendment rights, but do
Hmm.
you have a right to be on a private platform in
Hmm.
order to be heard? Is that a right? Especially, and does the government have the right if there are legitimate national security interests at stake?
Hmm.
I mean, is this the equivalent of putting Japanese Americans in internment camps during Pearl Harbor, which is a stain on our constitutional
Hmm.
history? Where we rounded up not Japanese, not even Japanese sympathizers, Japanese Americans, and put them in concentration camps because we were scared of them after Pearl Harbor and
Hmm.
what happened after the Karematsu case. Is that what this is? Or is this a legitimate exercise to protect national security, to keep out a foreign enemy who's using this platform to destabilize us? Which is it? And
Well,
has
they
the First Amendment play? Mhm.
right. I mean, I think that they haven't really shown that they are interfering. I mean, that's why they years ago had Oracle is an American company, is the one that controls the American data, and there's audits of that to make sure that's the case, to address that concern. I mean, we do have a right to use a private platform, even if it is owned by a foreign government. I mean, we do that all the time, right? Spotify isn't an American company. Musicians have a right to use that platform. That we have a right for the government not to shut down our First Amendment right. It's the Americans' First Amendment right, not who owns the company. I think that's really clear. And I don't think the government has shown that just because it's owned by a foreign company, that they actually have been using that to hurt our national security. I mean, to be frank, I think we have a stronger argument that Musk actually did interfere with our election, who is lying all the time to influence us. He is not born in America. If he was a Chinese immigrant, would that have been allowed? Or was it because he was white? I mean, are we really just, when the CEO of, TikTok was in front of the Senate, right? When they were looking at this before they did the ban, the Republican, I don't know which Republican senator it was. So many of these MAGAs kept on saying he was Chinese, and kept on saying he was Singaporean. And, because that's how racist, they have all become, or not all of them, but that is like a little bit of this, right? I mean, is it just because it's owned by China? To me, they would have to show evidence of it being. I think you cannot shut down a platform that 170 million people are using just because you may not like the videos that are put out, especially with the checks and balances they've already put in place with Oracle. Are the only ones that have access to the American data. And I do think Musk and Zuckerberg have done a lot worse with the disinformation and interfering with Americans than TikTok. So I think if you shut down TikTok, you got to go after them too, to be quite honest. I mean, is this where we're at? That's why I think these amicus briefs that are coming in are really kind of sounding the alarm, like the ACLU and others, because do we really want the government shutting down free speech platforms like this? What if YouTube got sold, to a Chinese government? Is that okay then to just go ahead and shut down YouTube? We're in a dangerous territory here, I think, if this ban goes into effect.
Well, listen, I think the record's going to have to be established, and it has to already be up there with the Supreme Court, that ByteDance is ultimately controlled by the communist Chinese, and that they are actually collecting data, algorithmic data and other data, personal data, that compromises our national security. If they can't meet that test, then I think you're in the world of the First Amendment rights. I mean, I'm not sure I have the right. I don't think I have the constitutional right to use Spotify, but I mean, I understand the expression of First Amendment.
But I mean, you do in terms of the government not restricting it.
Yeah. I mean, it depends on. Well, yeah, but I mean, if Spotify was owned by Putin, would that? I have a right to use a. That's the problem. This isn't just if this is Chinese bias. I'd be like, well, of course this is going to go down in flames. But it's not based on Chinese bias. It's based on, I assume, based on the record, evidence that the data is being used for Chinese information accumulation for their to use against Americans. I'll give you an example. It's well known that in China they put up giant screens in public squares to have people watch, sporting events. While you're watching that, it's watching you and doing facial recognition. It sounds like I just stumbled into an episode of Squid Games, but it's watching you and getting data from it because they have no problems. They think all biometric and other data is fair game in love and war. We know we're at war with China. We know that China has consistently tried to break in to American systems. I mean, we just had a case where it was determined that China has been living inside of 9 different mobile carriers for the last year. They just broke into the Treasury Department workstations. They're just cracking their knuckles, waiting for Donald Trump to come in to do the same thing. But if ByteDance has successfully separated themselves and set up walls and compliance walls and things, so that this doesn't happen, okay, then let's have the First Amendment discussion. But what did you think about Donald Trump's lobbing in his own amicus brief, saying, well, "Let's just wait till I get in, because I'll solve the problem."
Right. And I'm a big TikTok fan. I'm on TikTok. I think it's a great platform. And they didn't in the hearings, the congressional hearings, show any evidence that the Oracle separation of the data is not working. That's why I'm really anti this ban. So the Trump brief, well, it kind of goes with what we were saying, right? That as there's quite a bit of Supreme Court cases where the Biden administration argued one thing, and then as we hit inauguration, the Trump administration is going to have a different opinion, and the Supreme Court is going to have to look at that all. So I'm not really surprised that Trump said, maybe I can negotiate a different outcome. I don't know if that's necessarily going to, this ban goes into effect, in January. I don't know if the Supreme Court has that luxury of giving him a chance to negotiate. I don't know why Trump thinks he's a magic negotiator either. He has definitely not proved that. I'm not sure if the Supreme Court is going to count on his magic negotiations. The fact that we have the oral arguments for TikTok on January 10th, the ban goes into effect on the 19th. They did not stay the lower order. So most likely we're going to get their opinion before the 19th. Otherwise, what's the point of fast tracking this case?
Unless they stay it.
Yeah,
they could. My gut is after the oral argument, they're going to not admit that they're acceding to Trump's request, but they're going to stay it. They're going to say they need more time. It's a complicated issue. We can't. And so what's the downside? A few more days. Yeah. Really not going to. Right? It's not like 24. There's a bomb about to go off.
Yeah, and 9 days would be very fast for them to turn it around.
Yeah.
They would basically have to have pretty much decided just on the papers, which happens, right? I mean, a lot of times in court, you'll get, like you said, with the Justice Merchan, you'll get a tentative opinion or tentative decision on the papers, and a hearing just kind of reaffirms that. So unless they're really set on their opinions, 9 days would certainly not be enough for them to do their usual back and forth.
Look for a stay, but we will listen in on the oral argument, come back and talk to you on unprecedented. Why don't we hit very briefly last two topics to keep this sort of tight and not freak out our production team. Yeah, but if we didn't have a production team, I would say yes. Let's talk about Clarence Thomas. Why don't you do a quick update on the referral related to Clarence Thomas and where that's going?
Yeah, so Senator Whitehouse, along with a representative, both requested to the federal, conference that normally would refer complaints to the Department of Justice for a criminal investigation, for them to do that for Thomas, for his failure specifically to not disclose the fact that Harlan Crow bought his mother's house, essentially, paid for the tuition of his nephew, those kind of payments, not just the travel payments, because the travel payments, there was a little bit more vagueness, let's say, under the ethics rules, how much of that was for, private use versus not, whereas those tuition payments and the house payments are very, and the payment of his motor vehicle was very more clearly not kind of washed away. And the response was, because he filed an amended disclosure, he cleared that up, which, come on. If every criminal in this country, let's talk about Hunter Biden, what he would say to that, right? He failed to pay his taxes, and then he paid his taxes, but he didn't clear it up by paying his taxes. He got criminally prosecuted for that. So anyway, but this is how they came down with that. And also they said, we don't even know if we are allowed to refer something to the DOJ for the Supreme Court. And that really is the issue here, because who has oversight of the Supreme Court? Is it even, the court system has a mechanism for oversight of their judges, but does that apply to the Supreme Court? They don't even know. They said they plan on looking into the issue the next few months. And they also interestingly said one of the reasons why they don't know is because Congress hasn't specified it. We're not going to hold our breath that this Congress will specify it. But that, I think, is should be a communication to people like Senator Whitehouse, Democrats who really care about this issue, the next time they're in charge, to specify it and make this kind of force the issue a little bit more, let's say.
Another thing John Roberts doesn't care about, which is ethics and enforcing them, and looks like the other branches of government aren't able to do it either. And then lastly, we've got an anti-money laundering issue that has broad implications for potentially trying to rein in the Trump administration in its second go around, as it relates to universal injunctions, which many of the justices hate.
I know.
Gorsuch
Right.
has come out on
Mhm.
paper and said, I don't like universal injunctions being issued by these little federal judges. I mean, these federal judges under us. It's really not the way to go. And so, why don't you bring everybody? You're up to speed. We can do it
Yeah.
quickly with you. Talk about the anti-money laundering issue and what the Biden administration position is at the Supreme Court.
Okay, so this is what the interesting thing is. So they have this law about money laundering. They want to try to enforce the law. It is somebody sues, saying this law, is unconstitutional, and that a judge, a trial court judge, issues an injunction. What an injunction means is it's an order by the court to stop doing something, right? It's either a party stopped doing something. Here it was basically the Biden administration from stopping to enforce the law. A typical injunction only applies to the parties in front of the court because, frankly, usually it only matters, right? Let's say to the parties in front of the court. Like my neighbor does something, I want my neighbor to stop doing it. They issue an injunction telling my neighbor to stop doing it. But in this kind of situation, when a law, like a money laundering law, is going to affect like everybody, there's these things called a universal injunction, which the judge says the Biden administration cannot enforce this law anywhere. They don't have to say anywhere. They could just say in the state or anywhere. But universal injunction basically stops them from anywhere. The practice of a universal injunction, let's say under the Obama administration, it was only done 19 times. Under Trump, it was done 55 times. Biden continued that record. You can say because Trump had so many outlandish laws, right, that judges were trying to protect people from. But here, this particular case is asking the Supreme Court to take it as an emergency docket and asking them specifically to answer the question of whether or not a judge issuing a universal injunction is constitutional. And the reason why it matters, like I'm actually disappointed this question is coming right before we head into Trump because it is
We need it.
We need it. Exactly.
Right.
Like, I'm like, hey, you guys, maybe be quiet about this anti-money laundering. Can we like do this like 4 years from now? Because if Trump decides to issue a law banning, some sort of transgender rights, or not even Trump, right? Like anybody in a state, anywhere, a judge issuing an injunction protects all of us. Otherwise, it will only protect the parties in the particular case, and the rest of us will have to wait years while that appeal moves through the court. And we've all gotten a taste of how slow our justice system is. So it's a really good way of protecting the public from an illegal law, right? And so that's on the one hand why it's so important for us, especially during Trump, to do it. The reason why a lot of the judges don't like it, and actually even Justice Ketanji Brown Jackson has mentioned in an opinion, she doesn't seem crazy about it either, is because it allows for form judge shopping, right? This is why the Texas judge, like Republicans love it, because that one Texas judge can stop the Biden administration or the next Democrat administration from doing something really good. So it's the timing of this is what I really don't like, because if the Supreme Court takes this, they may not, it's up to Justice Alito. If they decide to take this and rule on it, most likely they will rule against universal injunctions, and that will take away a really important protective mechanism to do it. But it's also true that they may just decide, like they have for years, not to take it up because there are so many pros and cons to both sides. They may kind of kick the issue down, and that would be the best result for us right now.
Yeah, I don't know why the Biden administration is continuing to press this issue. I will withdraw the appeal,
Love it.
right, and stop talking about it, because I was ready to use the universal injunctions because we have our own versions of Judge Kaczmarek in Abilene, Texas, who banned with one stroke of his pen mifepristone, medication abortions and things like that. And we have our own versions of that. So I'd like to be able to use that. But it looks like it's going to be motoring along, I think. And then lastly, just as a preview, we'll come back next week or so. We'll talk, because it'll be next Friday when the oral argument on TikTok. We'll report on that right after that happens. And the other thing for us to keep an eye on in terms of things in Trump world that still haven't been resolved, we're still waiting for the 11th Circuit Federal Court of Appeal to rule on whether Judge Cannon was right or wrong to have dismissed the indictment against Donald Trump because she found that the appointment of the special counsel as a special counsel was completely improper, unconstitutional, and illegal, which blew a hole. It's the only precedent on the books right now until a higher court rules. The special counsel just lateraled the issue over to the Southern District of Florida U.S. attorney there to continue prosecuting the appeal. Trump's not in the appeal, but Walt Nauta and Carlos de Oliveira are. So there's at least it's not moot, and it's not a advisory opinion request. But as soon as Donald Trump gets in and he starts handing out pardons like Tic Tacs, not TikToks, Tic Tacs, then there goes that appeal. And we need the 11th Circuit to rule. So I'm hoping, and I think Jack Smith certainly is, that we get a ruling between now and the inauguration from the 11th Circuit. The problem, and then that'll be the rule. And then if anybody wants to take that up on appeal, if he pardons those people, no one's taken that up on appeal. It'll stay at the 11th Circuit, which is good. It'll be the only court to have ruled, so it'll be the highest court. The Supreme Court won't get involved. So that's interesting. That's a strategy and tactic of Jack Smith. Go ahead, pardon, but pardon after we get the 11th Circuit appeal. No one will be around to appeal it to the higher level, to the United States Supreme Court. If they don't rule until and he pardons them, game over. Case over.
Yeah.
And we'll be stuck with canon until a later day. So you and I will follow those things at the intersection of law, politics, and the United States Supreme Court. Thanks for joining Dina Sayegh-Dahl and me for a special, unprecedented, exhaustive, unprecedented after the new year, start the new year. Believe me, from now until the last oral argument in April or May and the final ruling issued in June or July, we'll be right here with you here on Legal AF, the YouTube channel. Take a minute, hit the free subscribe button, and help us build this pro-democracy channel. See you next week, Dina.
See you.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.